Hello, and welcome to episode 4 of The Legal Scoop. I'm Brendan Shannon. I'm an associate attorney with the law office Melissa Day. And if you're new to the show, this is our web series where we discuss notable wins here at LOMAD and just kind of give you some input on how these wins could affect workers' comp defense or could affect maybe some of your cases. Today, I decided to give a break to our other attorneys, and I'm going to interview myself, talk about a few wins that I've had recently. And specifically, I'm going to talk about a topic that I know that everyone who does workers' comp defense knows and loves, which is fraud. I'm going to try and talk about two cases. We'll see if we can get to two cases. I'm going to start with the first win, which is a case that's dates back a few months, but I think is notable and also useful to anyone who does workers' comp defense. Now, this was a fraud claim that sort of materialized fairly organically later on in the case upon investigation before a hearing. Now, the facts of this case were that claimant had made a claim for concurrent employment. And basically, the claimant was a home health aide who, a while after the case was established, uploaded payroll records showing that during a time where she was receiving benefits at Total, she was actually working and getting paid to work for her concurrent employer. There was a brief trial hearing on concurrent employment. Claimant testified that what she did was work. She was getting paid to do the same duties that she was doing for the employer that she had the comp claim for, taking care of someone who was actually related to her, but it was a 9 to 5, weekends off, and identical to the work she had been performing. Eventually, we raised fraud, and when we raised fraud, we argued that obviously the claimant was getting paid wages and did not disclose it while getting paid at Total. Now, what's notable with this case is that the claimant also denied any work to her doctors over several years and during the period that she was getting paid concurrent wages, and she denied it to multiple IME doctors. Now, when we got to the point of the fraud trial, the claimant argued that the work that she was performing and getting paid for while getting paid at Total was not actually work. The argument was that because she was related to the client that she was doing home health aid services for, that it was not work. However, we succeeded in that case where we countered that basically it's disingenuous to argue that it's work at the time that it was raised as concurrent employment, because that raised her wages and increased the amount of money that she was entitled to because her AWW went up. And then to subsequently argue that just because now that fraud's being raised, that actually that wasn't work, it was more akin to a stipend, and especially where the facts did not support it. The facts showed that the claimant worked normal business hours, had weekends off, and was doing the exact same duties that she was doing for the employer that was liable in the comp claim. So the reason I bring this case up is it sort of shows something. So in that case, we did get a fraud finding and a lifetime ban due to the amount of time that the claimant committed the fraud, the number of times that she saw her doctor and reported that she was not working, as well as the number of IMEs that she told she was not working while working, or that she told that she never had worked since the date of accident, despite that not being true. Now, what's notable about this case is that it sort of shows that fraud can come in many different packages. I think oftentimes in the comp sense, we think of fraud as either, a more obvious example of a claimant working while out on comp, more obvious than the claimant themselves and their attorney producing evidence of their fraud, or surveillance evidence of the claimant doing some sort of work or performing activities far beyond what they're supposedly capable of. But I think what this case shows is that, and it's something that we want, if you're a claims examiner, an adjuster, to look at with your files, is if there's a claim for concurrent employment, what period is it being claimed for, and what was the claimant being paid at? What did she or he tell their doctors during that period? It could raise a fraud claim. There's actually case law to support this. Part of how we won that case, we found board panel case law directly on point where a claimant raised concurrent employment. It was later discovered that during the period that the claimant was supposedly concurrently employed and getting paid, that they were also getting paid at total. They never disclosed it to the doctors, and there was a fraud finding. So our point is just to look for that type of thing when you have a claimant who's raising concurrent employment, because it's one of the more unusual scenarios where you could have a fraud claim on your hands, which can obviously significantly change your position in a file that maybe at first glance doesn't seem to be a very successful one. Another file that I'll just briefly touch on, another recent fraud one that we had, was a case where a claimant claimed an exacerbation. We had obtained surveillance of the claimant around the time of the alleged exacerbation, and we had obtained further surveillance sort of periodically throughout, usually scheduled around treatment or an IME. The surveillance on the dates that the claimant didn't attend an IME showed the claimant very active, even right after the exacerbation that supposedly rendered the claimant totally disabled. The claimant testified that it made him completely, incapacitated, basically. Increased his pain to such a severe level. Surveillance refuted that, and then on the date of the IME, the surveillance showed the claimant walking extremely labored, very slowly, with a cane, despite not using a cane while not at the IME on the same date, and walking normally, and not using a cane on any of the other dates recorded, and walking normally. And I think what's useful to think about with a case like this, now this is a more traditional fraud, someone who's exaggerating their condition to their doctors and exaggerating their condition, even more importantly, to their IME doctor, the IME doctor. But I think what's important to think about with a case like this, if you're a claims examiner or an adjuster out there with a file that you think maybe seems a little fishy, would be exacerbations. Exacerbations can sometimes, not necessarily pass the smell test, and it might be a reason to consider getting surveillance. And even if it's not an exacerbation, I think we all know when you have a file where it seems that maybe the claimant's been out of work a little too long, or the claimant keeps conveniently getting an exacerbation finding right when it looks like they're about to go back to work or reach MMI. That's a time where we recommend that you consider taking steps to obtain surveillance to see if these claims are legitimate. Sometimes they won't be, and in that case, like we did in this case, you could have a fraud finding on your hands. So those are the two wins that we want to discuss. I think they're notable, and like I said, in showing that fraud, like I said, can come in many packages. So don't ever count yourself out with a file. Take a look at it, and if you think things don't seem quite right, take a minute to think about whether there could be an approach, whether it be obtaining surveillance or taking a closer look at whether the claimant was potentially getting paid for concurrent employment while also out and getting benefits at total. It could prove really useful to some of your case files. So thank you for watching. That concludes episode 4 of The Legal Scoop. We'll be back next month, I'm assuming, with a guest. So thank you, everyone, and have a great rest of your day.